Pleasant good evening.
Hi, good night, hello.
Yes, good evening. We have Richard Jaggasar. He's an attorney at law in Trinidad and Tobago. He practices criminal law, civil law, constitutional law, and employment law. He's a member of the Trinidad and Tobago Law Association's Legislative Review Council, and he holds a Bachelor of Laws degree from the University of the West Indies and a legal education certificate from Hugh Wooding Law School. He was called to the Trinidad and Tobago Bar in 2016 and has been a member of the external panel of attorneys for the Legal Aid and Advisory Authority ever since. Pleasant good evening to you, Mr. Jaggasar.
Hello, good night, MikeeK. Pleasant good evening to yourself, pleasant good evening to all of your listeners, and thank you for having me on Gayelle tonight.
It's a pleasure, it's a pleasure. You, of course, are representing in this big case where it is you file a lawsuit against Weston Rollins, aka Cro Cro, and the copyright organization of TNT COT. And you claim that Mr. Rollins, with COT's permission, performed the Calypso title Another Sat Mirage is Outside Again, which allegedly named clients. Tell us, I mean, since the performance of the song, just how has things changed for your client?
It's drastically changed for him, for his family, for all of those employees under him and so on. I'm instructed that his businesses have seen a loss financially. His businesses have seen a loss in production and so on. He himself, of course, the law of defamation surrounds the issue of a man's right to have a good name, a man's reputation, a man's ability to build his name to a particular standard and be upheld in his community and his country to that standard and be treated fairly, and that name to be treated fairly. And all of that has been depleted by these statements that we contend are defamatory and that we say ought not to have been made at all. So his life and his family and so on, and I understand that it has gone so far as the fact that the case has been filed, I should say, so separate and apart from the defamatory statement, the fact that the case has been filed, and of course the recent injunction, I understand that there has been certain threats to life to my client and his family.
Now, the general public, the average citizen, may not be legally inclined to the ins and outs of the law. And in a recent interview, you stated that Mr. Rollins' failure to respond to the pre-action protocol letter is seen as a mockery of the judicial system. Expand on that, please.
Pre-litigation, during the advent of the civil proceeding rules, which are relatively recent in your judicial history, it's 1999, since the advent of the civil procedure rules, the pre-litigation correspondence direction came about for the sole purpose of preventing serious backlogs in the judicial system. So what do I mean by that? I simply mean that before one goes to court, one has to send a pre-action protocol letter, which gives the other side an opportunity to do two things. One, to settle the matter before we go to court. Therefore, we don't have to backlog the court system because it's a situation where we can settle. And two, it gives the other side an opportunity to mitigate the loss and the damages. In other words, I have a complaint. I have informed you of the complaint. Please do the best that you can to mitigate the loss in the event we do go to court. The defendant in this case has absolutely ignored that legal principle. He has refused to respond to the pre-action protocol letter while simultaneously commenting on the contents of the pre-action protocol letter in interviews and television stations and so on, radio interviews, TV interviews, and newspaper interviews. So therefore, you are telling us, the country, you're telling the judiciary, you're telling the claimant, I don't care about your claim. I'm not going to mitigate your loss. I don't care that you sent me a pre-action correspondence. I'm not replying. Bring it, come. That is the language he was using. And we say that is making a mockery of the system because you forced our hand to go to court on a matter which you ought really not to have.
No, let me weigh in on this from another perspective. We live in a land of pecan. Talk from since you were, whether it be secondary school, primary school, lineman on the block, as the case may be. But where's that line drawn now? And how has that line been crossed? From simple pecan to what you are saying has been damages socially, and of course the whole perception of your client where he's being threatened, his family. Where's that line drawn, and how far can you go over that line or can't? Please tell us.
So this is actually not new law. This is old law. This has been recited in our jurisdiction since Pandey and Gordon all the way up to the Privy Council. This was in Ram Logan and Rowley. This was in Jack Warner and Faik Mohammed. This is settled law. Defamation law in Trinidad and Tobago is quite settled. The issue at hand is, yes, Pekong is there. Calypso itself is an art form, and we respect it and we love it. But there is a line, privileged statements, creative license, if you want to, the art form, for example. Even your constitutional rights to freedom of expression are all limited by certain factors. Every law intertwines with another. In this case, those laws that I referenced earlier, freedom of expression, for example, or the general concept of our culture of Pekong, as you so rightly pointed out, the line is drawn by another man's right to protect his reputation, which is found in civil law defamation. So, and there are defenses. For example, you can make a statement about another man if the statement is true, even if the statement is defamatory, because the statement itself is a true statement for the content of the statement as justification. You can make a statement about another man if it's a fair comment. That means you can make a fair and reasonable statement, even if you can't necessarily prove the full content of the statement. And of course, the last defense is what we call qualified privilege or Raylan's privilege, which is often associated with newspapers and radio talk shows and so on, which is where they're entitled to make certain statements in the natural course of carrying out a story. That's why newspapers don't get sued for what have we commonly called clickbait headlines and so on, because they benefit from that quality of privilege. So I hope I'm explaining it properly in the sense that there is Pekong, but the line and the Pekong is protected by the defenses I just mentioned. But the line is you cannot plainly, without any justification, without any reasonable and fair research or any fair-mindedness, you cannot, with malice, intentionally defame a next man.
Yeah, this was somehow bold and crass, and there was nothing hidden as far as it seemed, the agenda itself. I mean, looking at it seemed to be somewhat personal. Am I correct?
That's exactly it. That is ideally what my argument to the court would, of course, be, and I would, of course, invite the judicial officer at the end of the day to put that in the judgment in my submission. But yes, in general, anytime someone is seeking to make a claim for defamation, there are certain principles they have to set out, and that is, of course, one, making a statement which you know to be false, knowingly to be false, making a statement with malice. You know, when a gentleman goes on another interview and says he purposely camouflaged the name, he's automatically telling the court that he cannot rely on fair comment, because fair comment is a defense which is defeated by malice. So he's telling the court, I intentionally meant the claimant, but I camouflaged me. So he can no longer rely on that defense.
Understand.
But that's aside. I wanna step back. I want to step back to the injunction that was granted on Saturday.
Yeah.
I understand that I'm instructed as of today that there are persons on social media who are inviting the song to be played on radio and inviting the song to be performed by other persons. Those persons may believe themselves to be immune, but they are not. The injunction that was granted, I'm not sure if you've seen it, but the injunction says that the first defendant, meaning Western Rollins, whether by himself, his servant, his agent, or otherwise. Let me pause there and explain what that means. That means anyone. That means himself, his servant, his agent, or otherwise. Anybody. Now let's go to what they can do. They cannot further redistribute the song, publish the song, or cause the song to be published or disseminated, posted on any forum on the World Wide Web, including but not limited to social media. And the song that we're referring to is the song that names the claimant. All right? So those persons who may believe themselves to be immune, they are not. They are very well making themselves targets to be sued in their own right, because redistribution of a defamatory statement is liable in its own sense, and they are making things difficult for the defendants, who may very well be held in contempt of court because of their redistribution. All right, and this injunction lasts all the way up until trial.
Yeah, all the way. Let me ask you, Mr. Jaggasar, on a personal note, have you been dragged into the politics of this song?
That's a very good question. I cannot say no, but what I can tell you is we spend years training to be attorneys and distancing ourselves from the facts of the case, and our job as judicial officers is to present the case insofar as the evidence touches and concerns the law to the judicial officer, and that's what I strive to do. Now, I cannot say no, I have not been dragged, but I feel as though it's my duty to always present the facts of the case to any judge or magistrate as the case may be.
So you haven't been threatened, or you haven't been told anything that out of the way as far as representing your client? That hasn't come about as the case may be.
Of course. That has happened. That has happened, but it does not faze me. At the end of the day, first and foremost, I have been retained and asked by a member of society, and I am bound by the Legal Professions Act to represent him to the best of my ability. Anything less than that would be a breach of my duty to the court and to my client, and I am simply doing that. Whatever may come thereafter, let it come. But I myself will do when I took my oath to be an attorney, I promise that I will do my utmost best always, regardless if the client is the Ishmael, regardless if the client is the Prime Minister, regardless if the client is the poorest man in the street. It does not matter to me. I'll perform to my best.
So basically, correct me if I'm wrong, but the consensus here is that Mr. Rollins should have known better.
He really should have known better. I mean, the case law on this is quite extensive. Justice Prasad himself, he went into great lengths in cases such as MS and CH. Names have been altered because the parties were minors and so on. There's another case, Janelle Burke. That's the police officer case and so on, where Justice Prasad went to great lengths to explain how does defamation intertwine, because it's an old law. It's an old law we took all the way from England. In fact, our Defamation and Libel Act says at Section 2 that we are bound by all of the case law in England. So going back to the case law of Justice Prasad specifically, he sets out how that old law applies to Trinidad and Tobago in our current landscape. He sets out memes, he sets out WhatsApp messages, he sets out posting videos, and explain how all of these things still can, and in this case has, amounted to a defamatory act.
Thank you. Any closing comments? Go right ahead, Mr. Jaggasar.
All I have to say is, ladies and gentlemen, what we have here is not an attack on Calypso, the art form, or any musical industry. This is simply a gentleman trying to save his name and reputation from certain malicious attacks. Anybody who says otherwise, anybody who says it's an attack on an art form, is simply misleading you and misguiding you. Someone maliciously attacked the gentleman's name, and he is executing his right, his legal right of due process, and taking him to the court. If he is wrong, well, then we will simply lose the case. If he is right, well, then certain things will happen. At the end of the day, he's entitled to do so.
All the best to you and your client, Mr. Jaggasar. It's been a pleasure, and thanks for taking time out to link with us here on The Observer. Thank you so much.
No problem at all. Take care.